What's up, everybody? Welcome back to Check the Record, hosted and powered by Equal Footing Institute. I'm your hostess with the mostest, Ellis Raspberry. Yeah, that is my real name. So I don't want to hear shit about it. Ladies and gentlemen, I ain't gonna lie to y'all, man. This is a brand new channel, and we are bringing real cases, real strategy, real justice, and real results. The things we do over here, ladies and gentlemen, are 100% legal. Okay, we're not gonna be doing anything that isn't legit. That's why it's called Check the Record, because we're here to get facts over fiction, facts over feeling, ladies and gentlemen. We're not here to argue. We're not here to make up, conspiracies or lies or anything like that. This channel is about the truth. If you're not a truth seeker, get out. All right, ladies and gentlemen. This first episode was actually a real interaction with me in court. Man, I had went to I was in Superior Court, against my children's mother, some things that we had going on with a temporary protective order case, ladies and gentlemen. So just to give you a little bit of context, before you will see me speaking with her attorney, originally up front, making a deal. He was trying to make a deal with me, ladies and gentlemen, trying to make a deal. That's crazy. So moving into the case, you'll get to see, just exactly how to poise yourself and just exactly how to speak. And I'm not going to say I did a perfect job, but I think I did a pretty bang up job, ladies and gentlemen. So with that being said, y'all enjoy the show. Y'all give me a follow, like, share, subscribe, hit the hype button, and let's get it. Now, how can I help you, sir?
Well, the judge invited us to go talk to see if we can reach any sort of an agreement on this case.
Okay.
She's asking for protection for you, for her and the children. We could just amend this to only have protection for her if you'd be willing to stay away from her. Agree to...
May I show you something?
Sure.
Come. I think you need to see it because I'm sure that you've seen the court record, right?
Yeah.
So, she perjured herself.
Yeah.
Judge Brendan F. Murphy is a named defendant in my federal lawsuit.
Yeah, I know. I've seen that.
So, with all of this being said, it seems that you would want to make a deal. So, let me ask you a question, counselor. Why does she need protection if she wasn't in imminent danger? Because not only does she not live at the address that she put, on the police report, which is a false police report, by the way. Not only was this added to my court record also, when I wasn't even served yet. So how about we take a look at that? Here's the court record for that. I have the court record. Hold on, I have all of them.
Okay.
No. These are all three of my court records that have had no answer. I've had no answer.
Well, that's not my job. That's... You filed those...
Well, no. I am in the federal lawsuit. No worries.
Yeah.
So my question is, what type of deal? Why would I make a deal rather for protection, or she's gonna get protection, and for 100% that she lied?
Well, I don't know for 100% that she lied.
No. I have proof.
Okay, well...
Well, so for example, she used the term, the last sentence in the message, you better lock in because I'm locked in and there's nothing I'm not willing to do to get to my children. Well, there's a whole paragraph before that she took out of context and came in bad faith in here with. She came in bad faith.
No, I don't.
Well, okay. Well, according to the law, she came in bad faith.
Okay.
And also, how about this? Before we even get into that, he needs to provide me with a delegation of authority and oath of office in relation to Article 3, Section 1 of the Constitution. This is a quasi-judicial tribunal. This is like, no, you have no authority unless it's delegated. I know this for a fact. Now, unless Mr. Murphy is going to violate me today, unless he's just going to give her what she wants, he's already a named defendant in recusal. He needs to recuse himself.
Because you filed a frivolous lawsuit.
A frivolous lawsuit?
Completely frivolous.
Completely? Really?
Yes.
Okay. So that means you already know about it.
I've seen a complaint.
Which means you're colluding. How does he know about it?
Okay. I think we've talked enough.
So let me ask you this before you leave. What deal are you really offering?
What?
What deal
What
are
deal
you really
am
offering?
I'm offering that if you consent to stay away from Miss Hall for 12 months, not contact her, then we won't seek any protection for the children, and you can resume your visitation schedule. If you're willing to consent to an order just to stay away from her.
Well, considering that this is the final child support order, right? She just served me with this. Our original judge being Angela Z. Brown, signed by G. Grant Brantley, whoever that was when I wasn't there, and signed by Brent Conway, and my name's nowhere to be found on the final order.
So that doesn't really have anything to do with
No,
it.
it's void ab initio.
It doesn't have anything to do with the deal I'm offering you is whether or not you're willing to stay away from her. I mean,
So how am I supposed to see my kids and stay away from her?
well, you have to, you can resume the video visitation. I mean, you're under order for supervised visitation, which my understanding.
Which is a false
Okay, but
order.
my understanding is you've not taken advantage of that. You refuse to do that because.
No, I didn't refuse. Show me the refusal.
Okay, all right. Anyway, do you want to take this offer or not, sir?
I want. No, let me tell you what I do want.
Okay.
I want to freely see my children without this void.
That's not up to me, sir. That's a judge. I'm not the judge. I'm just here on this one case. I don't have
So,
anything
so again, you're representing her
in this case only.
in this case only.
Mm-hmm.
Counsel, how long have you been an attorney?
45 years.
45.
Mm-hmm.
How many cases have you won?
Hundreds.
Hundreds.
I've done 600 or so of these, and I've probably won at least 500 of them.
Really?
Mm-hmm.
Are you going to be able to prove without a shadow of a doubt that she didn't perjure herself?
I don't have to prove anything sort of like that. Is it a yes or a no on the offer?
Absolutely not.
Go ahead and give me what you have so far, please. You saw that this is going somewhere in here?
Yes, on the back page.
All right, sir, and so I'm looking at the filing of May 7th.
The certificate of service, there is a certificate of service affixed to it, and it says, I hereby certify on this blank date of May. That LSA certified copy of the foregoing to be served upon the petitioner
Mhm.
in the Cobb County Clerk's office and or by U.S. mail to the address of record maintained by the court, and a certified copy delivered to the office of the sheriff. There's nothing in that certificate of service indicating that service, was sent to the court.
All right,
Objection.
so hold on. So it's the May 7th, I want to make sure we're all on the same page.
Okay.
On the May 7th, 2026 pleading,
What's the title?
I'm not gonna read all your long titles. It's May 7th, 2026.
What time?
Includes 1, 2, 3, 4. The fifth motion down is a motion to recuse the court.
There's multiple.
There's a motion, there are multiple motions, but the first thing we're gonna do is the motion to recuse Judge Brendan F. Murphy.
Okay.
I'm going to give you 5 minutes to argue that motion and that motion only, and I promise, if that is denied, you will have additional time to argue your other motion. You can argue the motion to recuse for 5 minutes, beginning now.
Okay. Before we begin, can I please see proof filed into the record of a delegation of authority given to you and a copy of your oath of office, Your Honor, before we get started? That properly establishes subject matter jurisdiction over this case. And if you can't provide me with that, I motion that we dismiss for lack of subject matter jurisdiction in relation to Article 3, Section 1 of the Constitution. Like, we can't get started before jurisdiction is actually proven on the record. It's a black letter federal law. Wouldn't you agree? Mr. Murphy?
Judge Murphy or Your Honor in this courtroom,
Yes, sir.
you have 5 minutes to argue your motion to recuse.
Is this a court of record? All right. Let the record show that the judge is proceeding forward without addressing subject matter jurisdiction. So are we gonna file jurisdiction on the record, Your Honor? Can you please show me proof, Your Honor? Judge Murphy.
You have 5 minutes to argue your motion to recuse.
Oh, well.
18 seconds in.
Well, we can't get started before subject matter jurisdiction is proven, Your Honor. Wouldn't you agree? Like it says right here, Your Honor, just so we're clear, subject matter is an issue, and it must be enforced implicating the constitutional rights of myself. Article 6, Section 2 of the Constitution states that the Constitution is the highest law of the land. So we have to prove that before everything gets started, Your Honor. I'm just asking for clarity's sake because these are my rights. These are my children. And so I'm making sure that I invoke those rights. Are we going to move forward? Or are you refusing to answer, Your Honor? All right, let the record show that the judge has refused to answer. As far as if we're just going to keep moving forward, your motion to recuse on May 5th, Judge Brendan F. Murphy signed a continuance protective order. And please note that I am moving forward. Let the record show that I am moving forward under duress and coercion because the judge will not refuses to answer. You signed a protective order, Judge Murphy, on May 5th, showing a evasion as far as your tactics are concerned. You are a named defendant in a federal lawsuit that is currently pending. If you could please divulge the statutory authority that allows you to not recuse yourself, or the statutory authority that says that you have to be served.
I'm going to pause your time.
Okay.
I understand that you have some kind of audio or video recording device.
Is that not First Amendment protected?
You have to comply with the uniform rules of Superior Court.
As far as am I breaking a constitutional law? I didn't know.
So it's Rule 22.
But the Constitution says the First Amendment, though.
It's Rule 22, so I'm going to pause your time.
Okay.
Motion to recuse, so we can work.
Or a lawsuit. So with that being said, Your Honor, you are to recuse yourself at this moment. You signed an ex parte hearing, and there's no constitutional law or basis backing up your claims. Not only that, Your Honor, I mean, she's perjured herself within the documents. There's a failure to state a claim. There's no injured party.
Do you have anything else on the motion to recuse?
Well, when we establish jurisdiction first, then we can move forward. Are you refusing to establish subject matter jurisdiction as relation to Article 3, Section 1 of the Constitution, Judge Murphy? I motion to dismiss for lack of subject matter, Judge Murphy. Are you refusing to comply, Judge Murphy? Are you gonna continue violating my rights, Judge Murphy? These are black letter federal law. I need proof of subject matter jurisdiction and your oath of office filed into the record, on the record, Your Honor. Well, with that said, Your Honor, I'm going to go ahead and dismiss this case. Since you refuse to participate, I'm going to assume that you've abandoned your neutrality.
Does your client wish to be heard on the motion to refuse? Do you have anything to add on that?
No, Your Honor.
All right, the motion to refuse is denied. Now we're
Please.
moving to the balance of the motions. So that is the balance of your motions filed on May 7th and your motion filed on the 20th.
Objection.
Now you're objecting to me allowing you to be heard on your motion?
Yes, Your Honor. I'm objecting to the fact that you haven't addressed subject matter jurisdiction. It's a black letter federal law.
First, the law requires
No, the law requires subject matter jurisdiction. But
when there's a motion to refuse,
mm-hmm.
to stop hearing the case on the merits, consider the motion to recuse,
Okay.
and then, and only then, if the court denies the motion to recuse, then we move on to the rest of the motions. That's what we're doing right now. So you now have 10 minutes to argue the balance of your motions in the May 7th pleading and the May 20th pleading. This is not a question and answer session. This is a time for you to answer your motions. I will give you 10 uninterrupted minutes that begin now.
Your Honor, before we begin, can you please file it to the record, show me proof of subject matter jurisdiction as related to Article 3, Section 1 of the Constitution. Nothing you're doing here is lawful today. Nothing. Article 6, Section 2 of the Constitution commands that you dismiss this case for lack of subject matter jurisdiction. Are you refusing to participate? All right. So you refuse to recuse yourself. You refuse to address subject matter jurisdiction because I am here making a special appearance, presenting in my proper person, propria persona, Your Honor. Are you going to ignore me and violate my rights, Your Honor?
I'm paying attention to every word you're saying, and I'm reviewing the pleadings and the relevant case law. Continue.
The relevant case law. Well, wouldn't you agree that subject matter jurisdiction is a fundamental law? Not statute, law. Constitutional law. Wouldn't you agree, Your Honor? Your Honor, you're not saying anything to me. I need some type of engagement, because jurisdiction is a black letter federal law. Challenging the court's subject matter jurisdiction. I object to the validity of the ex parte hearing. I'm moving for your recusal. Demand a production of delegation of authority and oath of office. I'm placing on the record the petitioner's perjury and bad faith moving in this TPO, Your Honor. Why are you not addressing the black letter federal laws? I'm preserving all my rights and defenses and objections on the record. Am I not speaking clearly enough? Am I not articulating enough, Your Honor? I can't hear you, Your Honor. The 5th and 14th Amendment, Your Honor, of the United States Constitution guarantee that no person shall be deprived of liberty and property without due process of law. You're violating my due process of law right now, Your Honor. Why are you not responding to me, Your Honor? I motion to dismiss, Your Honor, on the record. Is this a court of record, Your Honor? Where's your oath, Your Honor? These are questions that I need you to answer, Your Honor. Why are you refusing to answer, Your Honor? These are all lawful. Your Honor, I can't hear you, Mr. Murphy, Judge Murphy. Can you prove you have the delegated authority to do so? Is this an Article 3 court? Is this a quasi-judicial tribunal legislative Article 1 court, Your Honor? According to 28 U.S.C. 3002, subsection 2, this is labeled as a tax court. So how can I resolve the settlement, Your Honor? I'm in my proper person, Your Honor. Can you please divulge the statutory authority that allows you to sit here and not respond to me, please? Anything? No? Oh man, I'll just keep going then. You know, I got 10 uninterrupted minutes. According to Georgia law, let's use your law, since you want to use that. 19/13-1, while authorizing ex parte relief in narrow emergency circumstances, cannot operate as a mechanism to circumvent constitutional due process. The petition that's filed does not establish imminent physical violence. I request that the opposing party please show the physical violence. It alleges verbal communication during court-ordered co-parenting calls and the lawful publication of a public court document. This court therefore lacks subject matter jurisdiction to sustain the ex parte hearing beyond show cause hearing. Can you please show me proof? The opposing party, can you show me proof? Anybody, Your Honor? Subject matter jurisdiction? Can we have proof, please? On the record, is this on? Hello? Oh, we're just gonna keep ignoring it? Okay. I demand that you produce a specific delegation of authority, like I've said in relation to Article 3, statutory and constitutional conferring jurisdiction. The petition also fails to state a claim, Your Honor. Under, again, Georgia 19/13-1, family violence under Georgia law is defined as felony, battery, simple assault, stalking, criminal damage to property, unlawful restraint, or trespass. The petition alleges verbal communication during court-ordered, app-closed, co-parenting video calls, refusal to comply with a prior court order, and posting of a public court document on social media. None of these allegations, taken individually or collectively, accepted as true, constitute family violence within the statutory definition. The ex parte should not have existed. Can you please show me proof, or any type of proof, that you have the authority to do what you're doing, Your Honor? I motion to dismiss for lack of subject matter jurisdiction. I motion to dismiss for failure to state a claim. I motion to dismiss for bad faith and fraud upon the petitioner. She literally stalked my Facebook and decided to post it online and make a false police report saying that I posted her address, Your Honor. This is all in the motion, Your Honor. It's bad faith, Your Honor. Why are we not addressing the foundation principles of your law, Your Honor? Hello? You interpret the law through legal maxims, correct? Correct? Am I wrong? I don't hear anything, Your Honor. You still need to be recused. You're a conflict of interest. You're a named defendant in a federal lawsuit. Show me the constitutional law. Back up the constitutional law that allows you to be here. Motion to recuse you from the bench. Motion to dismiss for lack of subject matter jurisdiction. Motion to dismiss for failure to state a claim. Take your pick. Which one are we doing? I'm demanding proper delegation of authority and oath of office. I'm here under special appearance, Your Honor. I guess, you know, this is what we have to go through, right? As you know, individuals that live here, right? By the way, let the record show that my opposing party did say sovereign citizen. That is a derogatory term. That is derogatory and demeaning in its nature. So, Your Honor, my question is, are you going to dismiss for lack of subject matter jurisdiction? Are you going to dismiss for standing, no injury, there's no verified complaint, no verified affidavit? This is duplicative in nature. Your Honor, there's multiple court filings on this. Why are you not addressing me, Your Honor? You can't be reading the motions that fast. I put a lot of time in those, Your Honor. Are you going to address them properly? Subject matter? I'm only asserting my rights. Nobody's saying anything. Why are you not saying anything, Your Honor? I need an answer, Your Honor. Why are you not saying anything? You said you gave me 10 minutes, but I need you to dismiss this case. It's frivolous. You allow my adversary to make such comments that my pleadings are frivolous. Prove it. Prove it without a shadow of doubt. You're smiling, but you know he has to dismiss this case. What would you like me to dismiss it for? Collusive action? Actually, objection to that also. How do you know about the federal lawsuit if it's not active? Which means you need to recuse yourself. I motion to recuse you, Brendan F. Murphy. So whenever you're ready, you can, I rest, you can cut my time.
All right, that was a little over 8 minutes. Do you have any response to the argument concerning Mr. Raspberry's motions?
I think they're completely frivolous, Your Honor.
All right,
Objection, that's an opinion. Everything must be proven on the record, correct?
you can use your last 2 minutes to respond. You get the last word since they're your motions. The last 2 minutes begin now.
I motion to dismiss for lack of subject matter jurisdiction because Brendan F. Murphy has refused to recuse himself also, but he has refused to place the delegation of authority and oath of office on the record. This whole pleading, this whole show today is frivolous and ridiculous and honestly retaliatory in nature. Also, the petitioner needs to recuse, also is a conflict of interest because it's retaliatory in nature. She's also a named defendant in my federal lawsuit. The county of Cobb is a named defendant in my federal lawsuit. So this is retaliatory in nature. It is. The sheriff's department, police department, you, many other named actors. I motion to dismiss. I'm not backing down today. These are my rights. Everybody has their rights given to us by the Most High, the Creator. And I refuse to allow you to trample my rights today. Please provide me with a delegation of authority and oath of office. I have filed this into my records. Also, the affidavit that I have filed has gone unrebuted. So everything in the affidavit is consists to be true. Is that not right or wrong, Your Honor? I motion to dismiss for, once again, just so the record's clear, so we're on the court record. Motion to dismiss for lack of subject matter jurisdiction. Motion to dismiss is, for failure to state a claim. Motion to dismiss for a lack of injured party. Motion to dismiss for lack of standing. Motion to dismiss for fraud and bad faith. I motion that you file sanctions on the petitioner for moving in bad faith, Your Honor. Your Honor, Mr. Murphy, I'm trying to be as respectful as possible, sir. You haven't responded to me at all today.
All right, and that concludes the arguments concerning the motions filed on May 7th and May 20th. The motions are denied. We're now moving to...
Objection, Your Honor. You haven't filed subject matter jurisdiction into the record.
What's going to happen now is we're moving on to the case in chief.
Objection, Your Honor.
The way the process will work.
Are you moving forward without...
Rosenbaum will call his witnesses. You'll have an opportunity to cross...
Objection, Your Honor.
And then you'll have an opportunity to present any witnesses or evidence that you wish to present.
Objection, Your Honor. Subject matter jurisdiction hasn't been proven.
So I've denied your motion.
That's not a motion, Your Honor. That's a black letter federal law.
You were given 10 minutes and the motions are denied. Go ahead and call your first witness.
Objection.
Thank you, Your Honor. May I make a brief opening statement, Your Honor?
No.
Okay. Ms. Hall, what's your relationship with Mr. Raspberry?
We have twin.
Objection, Your Honor. Subject matter jurisdiction hasn't been proven.
So I've already...
I'm moving under duress. That's not something you can
You
deny.
have to be quiet. If you have a new objection, make it.
I do.
Otherwise, you have to be quiet because I've already listened to you and denied that motion.
That's not a motion, Your Honor. That's subject matter jurisdiction.
Thank you, Your Honor. So you have twins, and I believe that Mr. Raspberry has legitimated the twins, right?
Yes.
Okay. And I think that case is actually still open here in County, right?
Yes.
Okay, after the legitimation, at some point, you filed a TPO against him from Fulton.
Correct.
Is that correct? Could you?
Yes.
And I don't want to go into the details of that, but that was how was that TPO granted?
Yes, it was.
Objection, Your Honor. This is ridiculous. Subject matter jurisdiction hasn't been proven. Are you continuing to move under duress? I'm moving under duress here. You're coercing me.
So you...
No, Your Honor. These are my rights. These are my rights. These are my rights, Your Honor.
Matter jurisdiction argument has been denied.
No, Your Honor. It can't be denied. I can't waive subject matter jurisdiction.
Continue.
Please show me proof that I waive subject matter
Do
jurisdiction.
not interrupt have a valid objection that has not been ruled on, make it.
No, Your Honor, you can't rule. You can't waive subject matter jurisdiction.
And you've got a TPO and how?
I move under protest.
TPO for how many months?
It was initially for 6 months.
Okay, then what happened?
And then a few weeks.
Objection, we're moving
before the
forward without
TPO,
proof of subject matter jurisdiction.
ended, there was, the the respondent appeared to our home that we used to live in together, and then he was.
Objection, we used to live in the home together.
Aggravated
Sir,
stalking.
that's not you can't object to facts, you'll have your opportunity.
That's a
Disagree with
fact?
that,
That's an opinion. A fact is subject matter jurisdiction, Your Honor.
You'll have
Proof.
your opportunity to be heard. I have to lock in on the facts as presented.
Your Honor, you've abandoned your neutrality. You've abandoned your neutrality under 28 USC 545. Your Honor, you're violating my rights to due process.
So what's
What-
going to happen? I've already ruled on all.
How can I waive subject matter jurisdiction?
You're not waiving it, I've ruled that your motion.
How can you rule on subject matter jurisdiction when it's a black letter federal law?
This is your warning to not make the same objection again. You need to remain silent while the petitioner, you are correct, she has the burden to prove her case. And so I need to give her the opportunity to make her case. If you have a new objection, make it. Otherwise, you need to remain silent until it is your turn. So the last thing I heard was there was a TPO, that it was 6 months and it expired. And then what happened?
It didn't expire, Your Honor. It continued. He violated it at almost the conclusion of it by arriving at a home that we used to reside in together, pleading that it was, making a claim that it was void and that he had documents. At that time, I contacted the Cobb County Sheriff's Department. They arrested him at the home, and then we were sent back to court where the judge issued a 3-year protective order, Judge Manning.
Okay, so in that, 3-year protective order, that expired in, 2025?
Yes.
Objection, Your Honor. That temporary order, I filed documents in order, just the same documents that I filed with you, challenging, I did the same thing with Judge Manning and the same thing that you're doing. I'm challenging subject matter jurisdiction. You cannot rule or move forward.
What you need to do is you need to write this down.
Write it down. You're a named defendant in a federal lawsuit.
You can't keep arguing the same thing or I'm gonna remove you from the courtroom.
Yeah, actually, I am done with these proceedings, Your Honor. I motion to dismiss for lack of subject matter jurisdiction. You don't have the right to do the things that you're doing and on the record. So please, you're a named defendant. With all due respect, you're lying to these people. You're a named defendant.
Thank you, Your Honor.
Have a great day.
After-
All right, ladies and gentlemen, that concludes the first episode of Check the Record, ladies and gentlemen, powered by Equal Footing Institute. Y'all have been amazing. I appreciate it. Please like, share, and subscribe. And this is the Nation of Divine Creation. We out.